We'd like to welcome all of you in attendance to Quantum Business Law's monthly consortium meeting that we've been hosting across Canada now for a good number of years. Last 2 or 3 years, most of the programs that we've been running have been through Zoom and other video formats. One of the things that I'd like to get everybody to think about a little bit, is how well you're doing with collaboration. For many years, I've been kind of shouting from the rooftops that it's critical that lawyers and accountants and other advisors, investment advisors, financial planners, insurance people, they begin to collaborate together for the benefit of clients. And I've been hearing some feedback from a lot of you, many of you who I've had the opportunity to collaborate with over the years, and I'm hearing some very good things. It's encouraging. I'm just wondering how everybody here feels about collaboration these days. One of the important things I think to think about is the end result when we do act in a collaborative way versus operating in silos. And I think what I'll do to get things kicked off is I'll start off by addressing you accountants that are in attendance today. And I'm not sure how many of you are accountants, but typically we would have, at least 30 or 40% of our attendance as accountants, maybe another 30 or 40% as lawyers, and the balance is generally business owners and other professionals. So one of the things that I've been talking to a lot of accountants about across Canada is the fact that you're under an unfair burden, one that you really shouldn't be under, and that is that your clients most likely look to you as being the expert in anything to do with tax and anything to do with business law. And I think that's a little unfair. Business owners in general don't seem to understand that there's a difference between accounting and tax, as an example. And certainly tax law is a field all unto itself, that there may be overlaps between accounting and tax law, but certainly it's not a fair expectation for you business owners who are in attendance to look at your accountants as really having all those answers. So one of the things that I would point out, is that accountants are irreplaceable. They're amazing. A business can't operate without them. Prepare financial statements, do year-end meetings with business owners, and help to guide you to pay less tax in general. But accountants can't be expected to be trained in things like trusts, as an example, and other instruments that are very much related to business, corporate law, state law, things like that. So I think that in order to overcome that, we've given some thought to how we can create a platform that I'll talk about later. But before I do, I'd like to address the corporate lawyers who are in attendance. And I think there's, an unfair burden that's put on you. And I don't know that it's being put on you by the clients, but maybe by accountants. So accountants will often send a steps memo to a corporate lawyer. And the corporate lawyer will receive it and they'll say, okay, they want to do an estate freeze. They want to do rollovers, 85 rollovers, 86 rollovers, 51s, whatever it happens to be. And oftentimes the efficacy of that corporate structure that you're building is dictated by an accountant who is not trained on legal structures. That's a bit of a problem. Oftentimes the corporate lawyers really say, well, I'll leave the tax side to the accountant. But again, tax law and accounting are really two different subjects. So we see a void that can be quite damaging. We've seen individuals who have sold their companies or died and left huge tax bills just because of the fact that much of the problem was caused because of failing to address some of these very, very important issues. Now I'll address estate lawyers. So you estate lawyers in attendance, again, you do a great job of trying to provide for tax efficient transfer of assets to the next generation. But again, not without challenges and not without voids. How often do you estate lawyers focus on corporate purification, ensuring that the shares of companies which you're providing for in a will our qualified small business corporation shares and purification issues. Well, I can tell you that, many estate lawyers that we work with, again, they make the same comment when we leave that to the accountants. Well, one of the basic, for us, very basic solutions, there's many, but one of them is a butterfly strategy. Well, I will say that I've been in attendance as a speaker in an event with over 500 people. One of the co-presenters asked the question, how many of you accountants in attendance have ever performed a butterfly strategy? And guess how many accountants put up their hand? None. So I'm not saying that you haven't been involved in butterfly strategies. And again, if you're a tax accountant, you'll have more familiarity with some of these things than other accountants. And not every accountant specializes in tax. But there certainly are issues there that I would suggest are really, really important, right? Without belaboring this too much, I want to address the financial advisors who are in attendance. Banks, I know there's some people from some of the large banks today, and you do a great job, again, of maintaining asset portfolios and handling wealth management, things like that. Some of you from very, very large portfolios. And we do work with quite a few of the banks, and we're always grateful when they bring us in to resolve issues. Well, the good accountants, the good estate lawyers, the good corporate lawyers, and the good financial advisors and insurance people look for collaboration in order to resolve the problems. So you financial advisors, you obviously take your profession seriously. You want what's best for your client. You work very hard to that end. Some of you, I've had calls for very late in the night over issues where you obviously are committed and dedicated. But how often do you place an investment portfolio inside of a holding company or a life insurance policy? If you're a life insurance agent, how often do you sell $1 million premium or something like that into a holding company? Well, if you're ever thinking that the holding company shares may be eligible for capital gains exemptions, well, it might have been that you have created a situation where that would be irreparable. There may never be because of the policy, or maybe, you've got situations where you're just adding to another problem. So to that end, our firm has a solution that we're going to be talking to you about momentarily. Before we go further, though, I'd just like to share some news with all of you in the audience. And many of you know the former Chief Justice of the Tax Court of Canada, the Honorable Donald G.H. Bowman. Well, I'm saddened to share the fact that Donald Bowman passed away last week. He died in Toronto General Hospital peacefully, but I think his life is really one that is notable on many levels. There's no one in Canadian history who has contributed more to the fabric of our tax system than Chief Justice Bowman. And I've had the good pleasure of working with Donald Bowman for many years. He initially he was a mentor, and eventually he was a co-presenter. I presented with Chief Justice Bowman at the Ontario Bar Association for groups of CPAs and all other sorts of groups, annual conferences for accounting groups. Donald Bowman has rendered decisions that have changed our lives in various ways that sometimes we don't even stop to think about. One of the things that Donald Bowman was asked is, out of all the areas of law, why is it that you have chosen tax? And I can remember his words saying, well, and he always said that with a professorial tone, by the way. He'd say, well, other areas of law are interesting, such as corporate law, state law, criminal law might be interesting, and so on. But there's one area of law that affects everyone, and that is tax law. And that's why Don Bowman decided to get into tax law. We're glad he did. So there'll be a celebration of life, as I understand it, later on in the year. I'm not sure of the details, but those of you who know him might be look out for some notice on that. But we're very saddened by this, and really didn't want to go further without mentioning this news to you. So anyway, let's talk a little bit more about collaboration, okay? Because Don Bowman was really about collaboration. whether it was the tax moot that he taught at and that he basically founded. He essentially was really good at getting people to collaborate. He used to say to me, Todd, just pick up the phone if you have an issue with Crown Counsel, or with anyone else. All these letters going back and forth, you've got to talk to people. You've got to collaborate with them, right? So that's taking that as an example, right? So what we've done with Quantum, we have been running a consortium for a long time, and we've been asked for ways that we can try to formalize this. And what we've come up with is the Quantum Family Offices. And this is a platform that encourages collaboration between 5 disciplines. First of all, corporate and tax law. Second is accounting integration and tax advisory. State law, working with investment strategies, with wealth management groups and things like that, and taking into consideration all the family law implications that might exist. Now, the Quantum Family Offices essentially are designed in order to bring additional value, not only to you lawyers and accountants, but also primarily to business owners. This is all about wealthy families. It's all about successful business owners. It's about providing integrated advice that takes into account various disciplines where there are very prominent issues that are often overlooked that can cost millions of dollars for unsuspecting business owners. So what I'd like to do is I'll start off by talking about corporate law, and I'd like to take a moment at this point and like to introduce to you our audience, our panelists rather. First panelist I'd like to introduce is Michael Miller, who's a partner in quantum business law. Michael has decades of experience in mediation, litigation, obviously, dispute resolution of all sorts. There's many litigators that are very contentious, that don't necessarily act in a way that promotes the interest of individuals who are looking to settle a matter. Well, that's a strength that Michael really has. And beyond that, we're proud to have him in the program. Welcome, Michael.
Thank you.
I'd also like to introduce Andy Yip, and Andy is a brilliant tax lawyer that's with Quantum as well, who's very, very thorough, very studious, always able to get to the bottom of issues, and is always able to challenge ideas to ensure that the efficacy is strong. And I think that's a great asset. Andy, welcome.
Thanks for having me.
I'd also like to introduce Jordan Louie, who's with Quantum Family Offices and is involved in associate with quantum business law. Jordan's interest is more in the area of Quantum Family Offices, which, by the way, is a separate group. He's involved in financial services and the integration of financial services in concert with corporate reorganization strategies, estate freezes, butterfly transactions, as well as private equity and tax sheltering concepts. Welcome, Jordan.
Thank you, Todd.
Right. So this conversation today is designed to provide a platform that will allow you business owners to benefit and you accountants and you lawyers to be able to come together. Well, how does that work? Well, if you have to be an accountant, you can be special advisory counsel to Quantum Family Offices on your clients. So it's not as though, you're making a move or a change per se, other than to say that your clients who are growing, and I'm not talking about your top 1, 2, or 3 clients, I'm talking about companies that are doing well. We're providing a platform that encourages dialogue by the professionals in order to pick up on areas that are most often overlooked. So one of the things that we'll talk about is on the top left of the screen is under corporate services is corporate purification. And at this point, maybe we'll call on Andy Yip just to explain what corporate purification means. Would you mind, Andy?
Sure, thank you, Todd. In its essence, Canadians are entitled to lifetime capital gains. I think in 2022, it's around 913,000. Now, One of the assets that can enjoy that lifetime capital gain is called qualified small business corporation shares. Now, in order for someone's shares to qualify as what we call QSBCs, certain assets have to be within the company, or more specifically, certain assets should not be within that company. For example, non-active assets such as investments, stock portfolios, or non-active real estates, foreign assets or corporations should not be in that corporation at the time of disposition. Now, if your company is not purified as for having these non-active assets in that corporation, then when you dispose it, when you sell it, or at the time of death, you may lose that lifetime capital gain exemptions. So purification strategy is basically a series of steps or a structure to allow us to purify the company on a continuous basis.
Thank you, Andy. I think that this is one of the most overlooked areas, and sometimes just seems real obvious. The law states that all or substantially all of the assets of a corporation must be actively used in Canada domestically in the active course of business. Well, what does that really mean? All or substantially all is generally held to be what percentage, Andy?
90%.
90%. So really what Andy has just explained to you is at the time that you sell the shares of your company, at the time that you have a liquidity event of some time, maybe you issue IPOs or go public, at the time when you die, the value of your shares are considered, and also it's determined what the amount of capital gain is. In Canada, we don't have estate taxes, but 70(5) of the Income Tax Act states that when we die, our assets have to be taxed. Capital gains tax is calculated as if we've sold the assets. It's called a deemed disposition. In other words, the assets are deemed to be disposed of, even though they really haven't been. And if you gift the shares, say a father gifts the shares to a son, what happens then, Andy?
Well, it depends how you do it. There are different ways that we can give assets from a family member to another family members, but usually in a non-arm's length transfer, such as from a father to son, is deemed to be sold at a fair market value.
Yeah, and therefore subject to tax. So what we're really getting at, this is an important thing, and you can't wait to purify a company until you have a buyer at the door, because what happens, we'll have one hand tied behind our back. There are certain strategies that we can deploy in order to move assets out of a corporation to another company without creating tax, without issuing loans, without having any ties that are lasting. And some of those things cannot be done in contemplation of a sale. So if you're ever considering the possibility of selling your company, we've seen situations where parking a relatively small amount of cash, even perhaps a few $100,000, has cost a loss of capital gains exemption because they look back 24 months. Well, the test is different. And one of the things that we'd like everyone to understand is that there are two tests, there are really three tests. One is a holding test, and the holding test provides that the shares must not be held by a person that's unrelated to the existing shareholder. The second test is what Andy described, and that is that 90% of the assets have to be actively used in the business. And if you have money sitting in GICs or mutual funds or stocks or life insurance inside of a holding company, well, I think you may have just caused the loss of the capital gains exemption, and repairing it has to be done proactively, not reactively. All right, so we'll get into that later. Corporate structuring. Let's talk about corporate restructuring. Well, we often see problems, and one of the problems that we see is the presence of the non-active assets inside of companies. We also see a commingling of foreign as well as domestic assets. Sometimes we see corporations that are set up in the US, and of course, it can be problematic. And the reason for that is that the assets must be domestic. So I think it's very, very important to look at a corporate structure, in particular, if you have unneeded cash or surplus cash investments or US companies or US assets. It's important to consider that. Now, I heard an interesting fact recently, and that is that 8 out of 10 companies have no succession planning whatsoever. Any thoughts from our panel as to why succession planning is something that is important not to overlook? I'm going to say that failure to plan is the leading cause of excessive taxation. And it's the leading cause for businesses to fail. In fact, I heard another statistic, and that is that 9 out of 10 companies do not survive to the next generation, right? So quantum family offices are talking about issues now where lawyers and accountants are able to start looking at issues that are not everyday issues. You know, if you're a business owner, your accountant comes in to deliver the year-end statement. Well, there might be things that are there that would be good for other advisors to be present to discuss, other than just accounting, because things that you're doing can affect, have a further reaching goal. So if you're an accountant and you say that you have, clients that are paying a lot of tax and making a lot of money, well, this is an automatic feature that you can bring these clients into this family office arrangement. We'll look at corporate purification, we'll look at succession, and we'll look at other things too. What about real estate? One of the things that I often see that I believe is overlooked, and that is the presence of certain types of real estate inside of corporations. Not only is real estate often a non-active asset, if it's not occupied by a business, sometimes we see it rented out. Sometimes you have tenants there. Well, that could cause that asset to become non-active, cause the loss of millions of dollars of capital gains exemption, if you have enough shareholders, that is, right? One of the other things that we often look at within corporations, is things like loans between companies. Andy, why is a loan a problem from one company to another? Why can it be a problem?
In most instances, loans between companies, they might not be used for active business purposes. So let's say a loan to a related company, but the other company who received the loan use it for investments, then it might taint the company who made the loan to the other one. So obviously there's certain exemptions, like let's say if the company is between related companies and the loan were used for active business purposes, there might be exemptions under section 110.6. But in most cases that we've seen so far, the loans are usually will disqualify the companies as QSBCs.
Okay. Now, we work very hard to build up our businesses, our clients do. You want to protect your assets. Now, we see a lot of situations where at a corporate level, as well as at a shareholder level, there is a lack of awareness for vulnerability to litigation. We hear individuals say, well, we don't have to worry about being sued. We have insurance. We run a tight ship. And sometimes we see what we might consider a false sense of security. Michael, is it enough to have liability insurance within a corporation?
It's not, Todd. A great example is what happened in Toronto yesterday. There was a company that stored, they're an equipment rental company, but they stored large containers of gas in their backyard for use for many other things that the people need for building or whatever they're doing. And they blew up yesterday, a whole bunch of them. The building started on fire. All the employees were evacuated, and many streets around this company headquarters were had to be vacated. People had to leave their homes. So you can thank goodness no one was harmed physically. But you can imagine what the damages could have been if part of those explosions killed employees, killed neighbors, harmed neighbors, wounded neighbors. So that may be much more than any insurance policy that you have. $1 million policy, a $2 million policy is not going to cover that. We could be in the hundreds of millions of dollars. And so to rely just on insurance is not enough. We have to do asset protection and asset protection planning, along with wealth preservation.
Yeah, I just noticed a question, by the way, that we'll deal with in a moment, but I'm thinking about what you said, Michael. I think what you're really saying is we can't rely on the limits of provided by liability insurance. There could be claims that are greater than the limits. Is that what you're saying?
Yes, exactly. And in today's world, as we all know, people don't talk about $1 million anymore. They don't talk about millionaires anymore. They talk about billions of dollars and billionaires, and settlements and court cases in the United States are in the 20, 30, 40 million dollars with the blink of an eye. So it's going to be here. It's going to happen. And unless you're so insured up that you're totally protected, you can be wiped out by some fluke occurrence.
Mhm. Right. So I think that there's liability on many levels. You may have a contract that you get sued for non-performance, and it doesn't mean that you've actually offended the terms of the contract, but somebody might decide to sue you for it. I think there's different types of individuals out there as well. Some are rather opportunistic. I would call them predators. Creditors and predators. It's the second part that sometimes we have to worry about more than the first. Other times there could be a claim against an individual personally rather than a corporation that might result in the loss of their entire company. I just wanted to answer the question. Somebody's asking a question about whether or not you can claim a capital gains exemption where you have an operating company where shares are held by the holding company. Well, you can still claim the capital gains exemption in the shares of the corporation in the same way that you would the underlying asset. Now, the problem that you have is the shares of the active business or the operating company are in fact held by another corporation, which is the holding company. And as you are aware, capital gains exemptions cannot be claimed by corporations. Therefore, the holding company at the top can't sell the underlying company, the operating company, and claim the capital gains exemption. The shares of the holding company must be sold and the capital gains exemption claimed. Now, that is basically why it's really important to really look closely at the trial balances of companies and say, do we really have assets here that are active? Well, there are certain assets that should never be in companies. And we mentioned a few of them: investment real estate, marketable securities, life insurance with cash surrender value, even cash. So if you're pushing the dividends up to the holding company, well, you've got a few problems that I think you need to be concerned with. One of them is the loss of the capital gains exemption on the holding company shares, but the other is Section 160 of the Income Tax Act. Andy, do you want to explain to the audience what 160 is, 160?
In its essence, Section 160 is a tool for the CRA to collect tax debt when they from a taxpayer if that specific taxpayer has no assets to collect from. So 160 would basically a 160 transfer, or what we call it, it's a transfer of assets between two non-arm's length individuals, not individuals, but entities, and without or under consideration. Now, in such a scenario, then the CRA could go to the transferee of that transfer and collect the tax debt from that entity. Now, the most common scenario would be, let's say, a company declare dividend to its shareholders, and then the CRA come after the corporation. But let's say the corporation has no more assets, the CRA cannot collect from it. The CRA could go after the shareholder, since the dividend itself would be a 160 transfer, since it was paid without consideration.
Mm-hmm. Very good. So we're really talking about setting up an opco holdco to create asset protection, falsely believing that by moving a dividend from opco up to holdco means the money is safe, because as Andy's just pointing out, CRA can kind of reach through that and take the money from the holding company. So it might not be so safe. There's other concerns as well, but we'll move along.
Yes, Todd, I just want to add to that is if a husband or a wife transfers assets to their spouse and then says to CRA, I have no money, I have no assets, the court would look at it as a fraudulent transfer in many situations. So this is something that I know you talk about so often, because so often we think we can easily just transfer ownership to someone else. Well, you can't in many cases. And CRA, as well as your creditors, are happy to go after your spouse or your children or whoever you've transferred assets to improperly.
Now, by the way, folks, we're not just talking about problems. We're talking about problems that have solutions, and solutions that you can be empowered to resolve by and through collaboration. So oftentimes problems get brushed under the carpet. Sometimes people ask, well, when should I do an estate freeze? Well, sometimes because it's something that the accountant doesn't necessarily want to deal with, you'll say, well, you're not ready. Why aren't you ready? I can tell you that many times accountants do promote estate freezes, but sometimes the easy thing to do if I'm not ready is to say, well, you're not ready. In other words, let's look at it later with other problems to resolve. It never gets resolved. I'm not suggesting for a minute that most accountants aren't diligent in trying to do estate freezes. But what I will say is that most companies who need estate freezes don't have them. And I believe that the reasons can stand in the way is corporate purification. I mean, what is the point of freezing the shares of a company well, there is some point, but it's a lesser benefit. If you're not able to claim capital gains exemption and set up a trust and you have 10 shareholders or beneficiaries, indirect shareholders, well, you might have $10 million in tax-free proceeds that you won't have if you have it purified. You could have other problems that are standing in the way. And maybe what's happened is you've inherited a broken structure, a flawed structure, and you're trying to build a foundation, a structure on top of a broken or flawed foundation. Well, you need to be able to resolve that foundation in order to make it stand. Otherwise, you know what could happen, right? And that fear, that's everybody's fear. So let's move on and talk about estate freezes. Maybe Jordan, would you explain for us what an estate freeze is and what it's intended to achieve?
Yeah, so estate freezes are primarily done in order to mitigate or limit the taxes that will be payable upon the death of the shareholder. And so we'll go through some structures a little bit later that can show how that can be done. But it's normally done in concert with the establishment of a family trust. And from there, we're able to pass tax liabilities on to the next generation so as to kick the can down the road, as it were, as well as in some cases being able to multiply the capital gains exemption using various family members.
Mm-hmm.
And I mean, some of the other advantages of an estate freeze would be creating investment structures that allow for shareholders to segregate non-active and active assets so as to retain eligibility for the capital gains exemption and be able to safely make investments within another vessel besides their operating company or their holding company.
Mm-hmm. You know, I think that the concept of an estate freeze is one that we often take for granted and often is underutilized. In the United States, we can't do estate freezes. We do a lot of work internationally as well as cross-border US, Canada kind of structures. So the estate freeze concept is amazing. It's amazing because it allows us to be able to give away the future growth of your company, which has a high value, with zero tax. So oftentimes when a client asks us, when should we do an estate freeze? I would say, when you set up the company, do it now. First of all, it's a lot less expensive. Secondly, you don't lose flexibility. In fact, you gain flexibility that you don't otherwise have. If you have one class of shares and you happen to be common shares, you're holding 100 common shares in a growing company, well, it would be really nice to be able to make tax-free distributions of that capital to family members, would it not? Well, if you had to set up a corporation in the beginning using a trust, and you can do tax-free rollouts from a trust to beneficiaries, well, that is added flexibility, added benefits that you wouldn't have had otherwise. So what I'm saying is there is no age for a business owner to do an estate freeze. There is no value of a company. There is no level of sales. An estate freeze is a no-brainer. that needs to be contemplated. And if you have a successful business and you believe it's growing, what you need to understand is that your tax bill is growing as your shares and the value of your company is growing. Well, there's no reason to give it all away, because there's a provision there that says you can freeze or cap or otherwise minimize the value of the shares in your hands and push all the future growth down the road one generation with the anticipation of the children doing the same thing. Tax savings is often in the tens of millions of dollars and more. This is not something that's trivial. It's not something that should be out of reach. And it's never a situation that shouldn't be contemplated by any company that has prospect of growth, whether it's a brand new company or a company that's been around for 10 or 20 years. And another thing, it's never too late to do an estate freeze. So basically, there's many moving parts. Maybe Andy, you could maybe just describe a little bit about how an estate freeze is achieved, just high level, if you don't mind.
Sure, Todd. So before we go into estate freeze, I would like to introduce the concept of preference shares. So the biggest difference between common shares, or which I suppose most business owners are familiar with, and preference shares is that common shares do not have a fixed value, while preference shares often have a fixed redemption value. What it means that the value of the common share is often derived by the underlying corporation. Let's say a company satisfy all its debt, then the remaining assets can be distributed to these common shareholders. Meanwhile, with preference shares, their values are fixed, meaning that no matter how well the company does, its value is fixed. And at any point of time, the company could redeem those shares by transferring the fixed amount of assets to the preference share shareholders and to cancel those shares. And the way we utilize it in estate freeze is that for the business owner to exchange his or her common shares in the company for fixed value preference shares. Usually at the same time, a family member or a family trust will subscribe to common shares of the company, thereby allocating the future growth of the company to the family trust or the family members.
Yeah, I mean, that's a great explanation, everybody, by the way. Thank you, Andy. I think that the easiest way to envision and to understand how an estate freeze works is going back to Andy's initial comment. He identified the attributes of preferred shares and the fact that they have a stated value. Well, we know that common shares do change in value, they do grow in value. If you exchange something that grows for something that doesn't grow, well, you've just frozen the value, haven't you? Right? And that's really what we're talking about doing here. And there's many, many planning opportunities that exist once you've achieved that estate freeze. And you can also repatriate future growth back to yourself by doing something called a thaw, which means you're essentially thawing the freeze. So if you're saying, well, I don't know if I should do it. Well, wait a minute. If you're not happy, chances are it can be thawed, right? So it can be undone if that's what's desired. So it's not final, but the benefits are many. The reasons not to do an estate freeze are so few that I struggle to understand why business owners who have successful companies haven't done this years ago, right? But the whole reason that we're bringing this up is to say that it's not something that one profession can do in isolation. This does require it. An estate freeze cannot be done without an accountant. Accountants are necessary. They understand what's in the trial balance. They understand the company's culture. They know the shareholders. It's essential. It's like trying to do something that requires two hands with one hand. So therefore, we're saying that an estate freeze needs to be looked at through advisory sessions where advisors are meeting together, talking about existing situations, right? Let's go on from that and we'll talk about other kinds of capital gains tax planning. Well, there's many ways that you can plan for capital gains taxes. Capital gains taxes are not only on shares of corporations, but they're on capital property that appreciates in value. whether it's a corporation, shares, or whether it's real property, real estate, or other kinds of assets. Stock portfolios, there's a lot of different issues there. Now, when you're doing tax planning, there are instances where through proper and prudent planning that can result in the protection of assets, like Michael was saying. None of us are immune from being sued. And sometimes we can arrange our affairs in such a way that we can achieve greater protection than what is available in Canada. I'll refer to a couple things. I'll refer to the Fraudulent Conveyances Act. Now, for those of you that are not familiar with this legislation, it is provincial legislation, and it's every province in Canada. And it basically states that if you attempt to hinder, delay, or defraud a creditor, courts can make a special award that can pierce a corporate veil, break a trust, having the effect of losing assets that you believed were safe. Now, when you take measures to achieve proper asset protection by using something that's akin to a holding company without being a corporation, and I'm talking about either foundations or trusts. Foundations and trusts that are created outside of Canada can be used as a mechanism to hold assets that are situated here, including companies that have, say, life insurance policies, stock portfolios, other types of investments such as real estate. And one of the natural occurring consequences of having that kind of a structure is that you can have quite legitimately a company that's controlled by a trust company in one of these countries that controls billions of dollars of wealth for wealthy families all over the world. And the natural consequence is that capital gains tax goes from 25% down to only 13.25%. Now, I realize there's substantive CCPC rules in the latest budget. I realize that, some aggressive tax planning measures should never be done. And it's not something that quantum family offices would ever recommend. But we would say that there are legitimate ways that lack artificiality, that don't involve continuing companies to Delaware or BVI or anywhere else, that doesn't involve what they call skinny shares, right? Where you're putting control in where there's no value. All of the sensitivities, all of the issues that CRA has are ones that need to be looked at very, very closely. By the same token, we also look at the Duke of Westminster and the fact that our GAR structure in Canada, our whole GAR system, is based upon the fact that we are able to order our affairs in a way that we're paying less tax. And there's nothing wrong with that, providing that we're not avoiding or offending the anti-avoidance rules. So what I'm saying is there's things that can be done that's not accounting and not corporate law that can save millions of dollars in tax. And by being part of this collaboration, lawyers as well, bringing in clients, and then being able to look at some of these issues almost with, if you were to consider adjusting the lens of a camera, and the more you focus, the clearer it becomes. Well, that's what happens. That's one of the most profound things. I've never seen one situation where a business owner was bought in by a lawyer or an accountant through this structure, and the business owner wasn't thrilled, and so were the advisors. It's magical what ends up happening, right? There's a few other issues there that I'll just talk about rather quickly. There's various different ways that you can obtain an income, or not an income, I'll rephrase that. You can obtain cash flow through assets that you have of different types that in some cases is not taxable. Jordan, can you talk about leveraged insurance? Or that Jordan does a lot in leveraged insurance and has a lot of experience in this area when you're starting to combine financial service products such as life insurance, and you're combining that with accounting, state law, corporate law, family law issues, something unbelievable happens. Maybe just give us a brief idea about leveraged insurance, Jordan, if you don't mind.
Sure, absolutely. And I mean, as Todd had mentioned, it really comes down to the integration between accounting, financial services, as well as corporate and tax law. It's really something that magical happens once those areas are combined together. But as many of you would know, death benefits are not taxable, as well as cash surrender value within life insurance policies. And so it's really one of the best ways to be able to grow the wealth of shareholders. And from there, certain policies that have a cash surrender value that are held within a corporation can be used as an asset to secure lending on behalf of the shareholder. So every single year, in some circumstances, there are ways for shareholders to be able to access money every single year from a lending institution in exchange for the premiums that are being paid towards life insurance policies. But it's something that we'll tackle a little bit later. We'll go through some structures later on just to show how it works. And one of the benefits as well is that it works hand in hand with an estate freeze, as we're able to calculate what the tax liabilities would be at death when you're considering the capital gains exemption. And we're able to make up for that shortfall just to be able to cover any expenses that would be incurred in the event of death for the shareholder, well, eventuality of death for the shareholder.
Well, thank you, Jordan. You know, asset protection is an important thing. And one of the issues that I think one can do if you're doing an estate freeze, when you can mathematically calculate how much capital gains tax is paid, which would give rise to the capability to fund it. Now, one of the things that, you know, as tax practitioners, we find attractive about some financial service products, such as insurance, is that they have an almost sacred status in the Income Tax Act. There's no tax on the growth up to certain limits on tax-exempt insurance policies, and death benefits are paid tax-free. And it can also create very large CDA accounts inside of companies. And it's a matter of using these products in ways that I think is unusual. When we consider, you know, risk management, various different ways that you might be able to get sued, either personally or through companies, and you combine that with tax planning, well, I've already mentioned that sometimes there can be very large benefits. And one of the big things from a GAR point of view is we need to have bona fide purposes for what we're doing other than saving tax. So essentially, some of the things that we've been describing over the last several years need to have purposes that involve things such as intergenerational transfer of wealth, asset protection, capital gains planning, and things like that. So there's much that can be done. So one of the things then that maybe we just move along for a minute here, because I notice that time is running out on us. We're talking about estate planning. And again, we meet a lot of estate lawyers that, you know, that express a lot of appreciation for the value of this collaboration and working with accountants and, you know, tax law firms and so on. And this is something that's pretty important. And I'd say that there are many, many tools in this toolbox that aren't very well known. I'll just mention one or two. Essentially, we can often set up trusts in order to insulate against U.S. estate taxes. U.S. estate taxes are subject to exemptions, which are being reduced, as many of you know. And in some cases, we can insulate through the use of a certain kind of trust in order to insulate or reduce the tax bite. In other words, estate taxes can be avoided. Sorry. The other thing that we can do is we can look at increasing estate value, and this can be done through conversion of corporate assets, where insurance and other instruments are used, where you can use pennies to buy dollars, and effectively that can be achieved, where we can consider issues such as equalization of estate for benefit of children, grandchildren, things like that. All of the planning that is being done is all related to the issues we've been discussing. Sometimes we use NFPs, or non-for-profit corporations, and NFPs are basically kind of like a vacation club that can be used to buy a cottage. And if you have a cottage that you purchased recently that hasn't had any increase in value, it might be worthwhile considering transferring that cottage into an NFP or not-for-profit corporation. That means that at death, there's no tax to the parents when they pass away. cottages are generally something that stay in families for generations, or it's hoped they would be. And therefore, it's likely that there's going to be tax on a lot of high-value cottages. One of the other things that we sometimes do, if corporations are involved with foreign risk, we set up what are called captives or captive insurance companies that are designed to insure their own risk in places like the Caribbean. And basically, there is a very, very small exposure. 99% of the exposure or more is done by billion-dollar reinsurance companies that insure the risk. And in the event that we set up these structures, it allows them to be able to save significant amounts on premiums. High premiums can be in the millions, tens of millions of dollars, who knows, but it's often 40% savings where it's an act of business and where there's assets that are being insured, whether it be business insurance or automobile insurance or fleet insurance outside of Canada. We can bring exempt surplus back into Canada tax-free. Private placement insurance means you can take assets and move them into insurance policies outside of Canada and have the growth completely tax-free and have them commuted to the next generation without any tax whatsoever. There's lots and lots of things, too many really to mention. We've just cited a few for you here. Now, the other thing we talk about is family governance. And previously I mentioned that 9 out of 10 businesses will not survive to the next generation. So one of the things that we believe is important is recognizing the contribution of family members. Family members can sometimes feel unappreciated, feel as though the work that they've done has been not recognized. Sometimes we have issues where, all the good intention in the world can give rise to disruptions in family. Family infighting is a major cause of this kind of disruption. Family mediation is something that we do, and we can provide assistance to make sure that each family member has a role that's meaningful, that a role that is not only well rewarded and recognized, but where his talents can be used in a way that makes sense. Oftentimes there's issues with family members relocating outside of Canada. And that's an important issue from a tax point of view, because if, say, an adult child moves to California, well, that's great, but guess what? You can't do a tax-free rollout from a trust to a non-resident child. So in that situation, we set up a corporation here in Canada, and we have that child who lives outside of Canada holding the shares of that company, which would really give rise to the capability to do rollouts to that child's corporation. So really what we're looking at is several things: multi-jurisdictional issues, multi-discipline issues, since we're involved with accounting, advisory, tax advisory, corporate law advisory, state law advisory, investment strategy advisory. We haven't really talked about that too much, but at the end of the day, we do see too many situations where banks, life insurance people, as I mentioned, investment advisors, financial planners, simply putting the investments and life policies, other things in the wrong company. It's important that you don't do that. It's important that you look at the structure and make sure this makes sense. So this is really an opportunity to kind of welcome advisors into this platform that can assist to provide something that can provide this benefit from having all of these issues looked at in a more collaborative way. We welcome everybody to that. We've got about 5 minutes left, and my goodness, we've got so many subjects to talk about. So what we
I'd like to use one of those 5 minutes if I can. You're nodding your head, yes, I assume?
Go ahead, Mike.
Yes,
Yeah.
Thank you. One of the advantages of the quantum family offices that we have to look at is that when I started to practice law, lawyers did everything. They did the business stuff, they bought the houses for you, they set up your company, they litigated, they did everything. In today's world, there's so many specialties that if you use one particular law firm as an example, you may be using 5 lawyers in that law firm. The same goes for an accounting firm. They're so specialized today. That's why the family officing office idea works for everyone, because your accountant needs to give advice, as does your real estate lawyer, as does your patent lawyers, as does your litigation lawyers. And when we talk about a litigation strategy, we're talking about us representing your interests. And we know your background, we know the client's needs. And as a result, we're able to get the right team together of the right lawyers in every different range of what their knowledge is, to bring the client the good news that the client needs. So it's no longer acceptable just to say, I've got a good lawyer, because you do have a good lawyer, but that good lawyer may be a specialist in one area, and you may need other people working on your team. And that's something that the quantum family offices will offer. The other thing, I just wanted to ask you a question, Todd. We know about BVI and we know about Delaware. Are those, and we know what the government has said, are those companies salvageable? Is someone who's got opened up an investment in a BVI or Delaware, are they able to correct that now?
Yeah, I would say that you want us to look at it before CRA comes knocking. One of the concerns is that companies across Canada are being audited. And in particular, CRA is on the hunt for companies that have been doing abusive and aggressive kind of tax treatment, tax planning. So if you do have a continuance in those areas, 100%, Michael, I think it's a good thing. I think that I want to just advance what you said a little bit more, and that is whether or not you have one lawyer, three lawyers, or a whole team of lawyers, the same concept applies. I can tell you that, one of the things that the family office has been working on recently is strategy for litigation. And oftentimes a litigator's objectives may differ from that of a client's for a number of reasons. Sometimes there's an inherent conflict of interest that takes place. So say, as an example, there could be an opportunity for a settlement for $3 million, but in 5 years, it could be worth $50 million. Well, there's always that conflict that's built in when you're trying to litigate a matter. Sometimes there's situations that need to be done in a way that's outside of the common way that law is practiced. One example is a family law situation that we've been assisting with. And essentially, we see a situation where there are shareholders that already have an equitable distribution of net family property, but yet there's a need to do a valuation report for some reason. Well, if you're not dividing anything, what is the issue with a valuation report? What about the other two areas? Say you're dealing with spousal support and child support. Well, there's many things that can be done, and oftentimes what is overlooked is the fact that if you're going to take money from a company and pay tax at a very high rate in order to pay, say, a $10 million fee, or not a fee, but an equalization payment, well, maybe it can be done without the need to pay tax. Well, how can that be? Well, through a divisive butterfly strategy, that can be achieved. And there's just too many examples really to go into. So what we're planning to do in the next couple of minutes is we're going to give you an idea of what we're going to cover in future sessions. So one of the things that we're going to be talking about is the anatomy of estate freeze, how estate freezes work, how this is an easy process. We're going to be talking about parties to a trust, who they are, what is a trust, how can trust be used in ways that can benefit business owners. We're going to be talking about trust for USA property, United USA property that otherwise is subjected to large estate taxes. We're also intending to describe a butterfly strategy for you that is considered by most accountants and lawyers very exotic. Somebody once said to me, oh, there's only 2 or 3 of your firms like you that do this in the whole city of Toronto. And I don't know if that's true or not, but what I will say is that a butterfly strategy is considered uncommon. And for us, we do it every day. Well, not every day, but I'd say every week we're involved in this work, but reasonably speaking, it's as common for us as anything else. There's various different aspects to this kind of work. we see situations that are common where you have an OpCo Holdco situation and you're loaning money from the Holdco down to the OpCo that may not be for active business purposes. Well, there's no capital gains exemption. We see situations where you have a real estate company combined with an operating company. All these problems coexist. One of the solutions that we have here is a way that we can create a structure where profits that are earned by an operating company can be segregated. If you look at the previous slide, we'll describe it later. But what we're really trying to do is to separate the operating company from the real estate company. So notice we have two holdcos instead of one. Well, that solution is one of many, and generally speaking, is very necessary. And I'm going to say a large percentage of companies that these kinds of strategies need to be deployed. The other issue is that we can change the ownership of loans through these kinds of strategies, or we can move them to a corporation which would never have a need for a capital gains exemption, where we would not purify the company. Then money can be then reloaned back to these other companies. Meanwhile, we can funnel money through the operating company as intercorporate dividends, move them into what I'd call a sister company. And maybe, Jordan, we could just finish this off by explaining how you could take, say $1 million a year from a sister company funded by the active businesses and convert that to cash flow. Can you explain that?
Sure, absolutely. So as we had mentioned earlier, we'd be looking at a permanent life insurance policy with cash surrender value. And each year, as the premiums are paid into one of these policies, that cash surrender value grows as a corporate asset. And there are ways that the asset value within that life insurance policy can be pledged to a bank or another lending institution as collateral, with the goal of securing a personal loan to the entrepreneur or the shareholder of the company. And so in many cases, the loan that would be received back by the shareholder would be equivalent to the premiums that are being paid out every single year to life insurance policy. So it's mainly meant to address expenses that would be incurred upon the death of the shareholder. But the other advantage is that it's enabling that shareholder to be able to have a large amount of money in hand every single year that's equivalent to the premium that's being paid on behalf of the company. And so they're receiving this loan tax-free rather than paying 50.7% or so, as that would be equivalent to any dividends that they're taking out from the company. So it helps them to have a tax-free solution to be able to access a large amount of funds every single year, but at the same time, be able to secure a very large life insurance policy that has a death benefit that's tax exempt, as Todd had mentioned.
Yeah, that's excellent. So I noticed that we're just past 1 o'clock, which means that we have about 13 minutes for questions. So it's our tradition to always finish on time. And of course, we're looking to finish at 1:15. So we'd like to open the floor for any questions that anyone has. Please feel free to chat us the questions, and we'd be happy to try to answer them. I noticed that somebody's asked if we have handouts, and certainly we'll post a copy of this webinar on our website. And we do have a whole catalog of past programs. I'm not sure how many, but quite a few of them on various different subjects. But we'll make note of that, and please reach out to us and we can send you a copy of the PowerPoint as well. Absolutely.
And I think we just wanted to answer some questions as well. I see just one question is regarding the guarantor fee that will be payable in order to be able to secure a loan using a corporate asset. And so, yes, this can be looked at as a shareholder benefit. And so on that, for that reason, that's why there has to be a guarantor fee that's paid from the shareholder towards the corporation to diffuse that risk, because they would be deriving benefit from leveraging a corporate asset. And so usually the rate would be about 1.5%.
Mm-hmm.
Todd, did you have anything as well to add just regarding shareholder benefits and guarantor fees for insurance?
Well, I think that shareholder benefits are, really important area to consider. And of course, we're dealing with two things. We're dealing with 15(1) of the Income Tax Act. And essentially, where a benefit is conferred upon a shareholder by using corporate assets, it's always important to try to determine what the value of that benefit is. And essentially, that's why we're looking to, when we do planning and where, an affiliate firm or one of, an insurance person or investment person brings this in, we'd say, well, let's make sure that we're paying for it, right? So 1% is probably a reasonable amount. I would say it's fact specific. So in other words, if an individual would have the credit worthiness to be able to borrow the money without the assistance of the corporation, one could argue it has perhaps a lesser value. But I would say that, 1 or 1.5% is generally considered to be a fairly reasonable number for those things. One of the other things that we sometimes see as well is individuals that have significant loans owed to the corporation. In other words, loans that are advanced to shareholders as shareholder loans must be repaid within 12 months of a year end. If it's not, then it goes into income. We can assist those people in that situation by coming up with methods of repaying those loans without a lot of difficulty. One of the other questions is, should a Holdco own large life insurance policies to avoid capital gains taxes? Well, in this particular case, it would be a grave error to put the whole, use this holding company, or if we're looking back at slides previously, say this is your structure, to put a large life insurance company in that holding company would really cause the loss of a capital gains exemption. Same with this structure. So what we're really saying is to use a sister company. We call it a sister company because it has a different parent. So, sorry, the same parent. So the individual or individuals who own the holding company would, assuming they're unrelated, they're related parties rather, we would be able to transfer funds through a series of transactions that are very detailed in order to achieve that. I will say that one of the changes that recently have come about in the legislation is that siblings are no longer considered unrelated for this purpose of determining whether or not we can, utilize, say, a butterfly strategy. One other comment I'll make is that paying large dividends from an operating company to a holding company can get caught under the purpose test in section 55(2), the anti-avoidance rules. So the sorts of structures that we're talking about now can actually prevent that problem, right? As far as large dividends that are not safe income, because otherwise you do safe income calculations in order to determine what you can move without really losing sleep at night, right? So what we're intending to do in future sessions is, as we collaborate more and more with business owners, lawyers, and accountants, we're intending to share in real time, some of the most fascinating things and experiences that are coming out of this. And we'll be having various different guests involved. But anyways, what I'd like to leave this with is to say that we'd really like to thank you all for being here with us today, and think of this as an opportunity, because we keep being asked, how do we collaborate more? Well, here's a way that we've come up with that can allow you all to be accountants and lawyers to be essentially special counsel on your client situations, because you are the very best special counsel that your client has. And by doing that, it's going to allow you to be able to solve problems that the client probably didn't even know he had. You're going to add value to the client and add intrinsic value for yourself. That goes for investment advisors as well. So I'd like to thank everyone for attending today, and we hope you enjoyed the program. Until next time, Jordan, when is the next session that we have booked?
I would have to, we'll have the invitation sent out for the next program.
I believe it's in mid-July.
Yes.
So right during holiday season, but we're very eager to assist in any way that our group can, and it's all about putting our minds together. As Aristotle said, the individual parts are greater than the sum total, right?
You weren't there
Paraphrasing
when he said
Plato.
it, were you, Todd?
Sorry?
You weren't there when he said it.
I'm old enough, Michael, that I could have been, right? But anyways, thank you very much to everyone for your attendance, and we look forward to speaking with all of you again. Please contact us if you'd like to be part of this collaboration. Take care. Thank
Thanks,
you
Todd.
all, the
Bye,
expert
everyone.
panel, Michael Miller, Andy Yip, Jordan Louie, thank you very much.
Thank
for
you,
your
everyone.
representing.
Thank you.